Okay, we're going to be starting the chapter on law and the courts. And so this one has broken down into two parts. I'm going to be covering chapter 10 first, and so parts of chapter 10, not all of chapter 10, so that way you can understand what I'll be talking about in chapter 9. So the parts that we were going to be talking about in chapter 10 are, we're going to be talking about civil law and what constitutes civil law. We're going to be talking about what constitutes criminal law and the different types of criminal cases that may be out there, or what the different types of cases that are considered to be criminal cases. We're going to be talking about original jurisdiction, or where a case is heard for the first time, and then we are going to be talking about appellate jurisdiction if a case is going to be appealed from the lower courts from the original jurisdiction courts.
You know, we live in a very litigious society. And what a litigious society means is that we are kind of like trigger happy when it comes to lawsuits. If somebody wrongs us in some way, we are very likely to sue them. And so we often go to the courts to help determine different types of rights. And this has been the case, traditional or historically, I should say. For example, a lot of our legislation on civil rights and affirmative action came from the court cases because there were groups of people that were disproportionately affected by the types of laws that we had, or even society and things that were going on. If you think back about the civil rights issue, and I know you were not born at that time, that was way far back, uh, but certain segments of society, the minorities, the ethnic minorities, were not being treated very well. And so there were activists that actually got it to the court system, so that eventually we did have the Civil Rights Act of 1964. And shortly after that time, this thing called affirmative action. And this thing called affirmative action is not really a law that was passed by Congress. That is an executive order, something that was signed by a president, and each president can decide what affirmative action should kind of look like. So we're going to be talking about a couple of types of cases, civil cases and criminal cases. And we're going to be talking about the different criteria and the types of cases that involve civil law and criminal law as well. Okay, let's talk about civil cases first, or civil law. And so what this one is that it's a lawsuit that is initiated by individuals. It is initiated because one individual has wronged another individual, and so that person is suing. It could be something like, you hit my car, you don't have insurance, I have a lot of medical bills, I'm suing you because I want you to pay for my medical bills. So what they're looking for is responsibility, not guilt. That person that caused the accident is responsible and owes you money. So basically, it's a plaintiff and a defendant, and they're private parties. You are the plaintiff if you sue. You are the person being sued is the defendant, and it's initiated through the use of a petition. That's what it's called. You go down and file paperwork, and usually you do need an attorney to do this, depending on the amount that you are seeking. And we'll talk about more about that when I cover the part on the different types of courts in Texas. All right, this is important. Now, what you're looking for is called preponderance of evidence. Preponderance of evidence, because basically that's saying which side has the best evidence to win the lawsuit. And so a lot of times it depends on how good your attorney is to present this evidence, because you are looking to win your case. You're looking to say, yes, this person was at fault. This person did cause this accident. This person did wrong me in some way. And so what you're looking for is you're looking for compensation. You're looking for money, in other words, money. And so this is based on English common law. All of our civil law is based on English common law, and that's basically said it's judge-made law, and it's based on precedents. Look at the way it's spelled. It's not precedents like the President of the United States. It's which cases came before this one, and how were they rendered? What decision was rendered based on these precedents? So it's English law, and almost all of the states in the United States follow this English common law ideology or this practice, except for one, and that one is Louisiana. They still have the Napoleonic code, but we have English common law. Okay, so in this English common law, what that says is that there has to be laws that are passed. And these laws that are passed by different legislative bodies at the state level. You know, many of the crimes that we have are at the state level. There are federal crimes as well, but the majority of them are at the state level. Each state has a different way of looking at certain things. You know, some things that may be acceptable in Texas may not be acceptable in other states, like, for example, the open carry type of regulation for the guns. You know, not all states would adhere to that, but, you know, we don't seem to have a problem here in Texas. But so that's just like one example of it. So what happened, the laws are passed and they're written into these code books. And so the code books, there's one for criminal law, there's one for civil law. And so we say that these laws are codified. And so a lot of times they include a lot of these common law principles of this common law, of this English common law that we base our laws on. So let's talk about the types of cases. When it comes to civil law, there are numerous types of cases. One of them would be personal injury, and that would be, you hit me, I broke my arm, I can't work, you know, I'm looking for damages because I can't work, you have to pay for my medical bills. Okay, that's considered to be personal injury. It could also be child custody or divorce. You know, it could be, I want custody of my child, or joint custody, or whatever. So that would be another example of a civil case. It could be breach of contract, and breach of contract is basically, well, I hired you as a contractor to do some work on my house. I paid you some money already and you haven't done anything. You know, you need to pay me back or finish the work. And so if the person decides not to finish the work, he breached that particular contract that you had with him. And so you can take him to court in a civil matter. Other types of cases would be like labor disputes. And so for this one, let me talk a little bit about the labor dispute. You know, in the state of Texas, way back when we were talking about the history of Texas, I told you at that time that Texas is an at-will state. It's not a right-to-work state. And so there are like ramifications for that. So basically it says this. It says if you're working someplace in the state of Texas, you can be fired, let go, laid off, whatever term you want to use, for no reason. And you have no recourse. You have nothing to say about it. And if you're saying, you know, I feel that I was wrongfully terminated, well, you know what? You have to go back to those. When I talked a little bit about the Civil Rights Act and affirmative action. And so the Civil Rights Act, it says we do not discriminate against race, color, creed, national origin, gender, whatever. So, you know, you might say, I was fired because I'm a woman, or I was fired because I'm Hispanic, or I was fired, you know, for whatever reason, or because my boss was hitting on me. And, I said no, and so he fired me. So you would have to go back to one of those reasons, and we call them protected classes. You have to go back to one of those reasons and say, I was wrongfully terminated because they wanted to bring in somebody else in, and they wanted to get rid of me because I'm a woman. So, so you have to go back to those protected classes through the Civil Rights Act. Okay, I want to talk a little bit about family law, and this part comes from Chapter 10. I told you we're going to be doing some parts of Chapter 10, and the reason I want to talk about family law is because here in Texas it's real different than it is in a lot of states, and there's two things that we're going to talk about when it comes to family law. One is common law marriage, and the other one is the community property state. And the reason I want to talk about common law marriage is because, in the state of Texas, if you decide that you want to cohabitate or are cohabitating with somebody, you need to know what your rights are. So let's talk about common law marriage first. Well, in the state of Texas, there is no time requirement as to how long you have to live with someone. If you claim common law marriage, what you need to do is that you need to hold yourself out as being spouses, that you hold yourself out to society saying, this is my husband, this is my wife, that you may own property together, that you may have joint bank accounts or joint leases, that you are accumulating assets together. So all of that says that you have a common law marriage, and in the state of Texas, a common law marriage is just as valid as a regular marriage. So, if you have children born of this common law marriage, they are legitimate children. They are children born within this common law marriage, but they are considered to be legitimate. And so, if you decide to split up, just like if you were getting a divorce, you need to go, or that you're getting a divorce if you got married, like through the justice of the peace or the priest or whatever, you do need to get divorced in this common law marriage. Now, what happens a lot of times, though, is that, if people just kind of split up, and so the big issue about this is that if you just like separate and don't go through the divorce process, are you going to be able to get child support from this person? Are you going to be able to divide up the assets? Now, if you are just living with somebody, but you're not holding yourselves out as husband and wife, that's not an issue. You do not have a common law marriage. So I'm just telling you, kind of, watch what you're saying, depending on where you want to end up. All right, the second part of the common law marriage, the family law that I want to talk about is that Texas is a community property state. And so what that means is that everything that you accumulate while you are married, and if you get divorced, you have to divide up these assets. So in the divorce, you will divide up the property. I put alimony there, but Texas doesn't really have alimony. They call it spousal support. And so it's not for a very long period of time, and you have to have been married for, like at least 10 years to be able to get spousal support. And it's usually because, well, as a homemaker, I don't have any job skills or whatever, so you have to, in the meantime, be getting prepared to go to work. So spousal support for a short period of time if you've been married for at least 10 years. Child support will be allotted. Custody will be decided, as well as visitation for those children that you may have had within whatever marriage, whether it's a regular marriage, traditional marriage, or if it's a common law marriage. So these community property criteria, it's not just for common law, it's for everybody. It's for everybody in the state of Texas. Okay, let's talk about criminal law. And so when it comes to criminal cases, these are crimes against the public. It's that you committed some type of crime, again, that's out there in the code, and that's codified in one of these penal codes. And penal just means related to prisons. And so it may be theft, it may be sexual assault, it may be murder, that type of crime. And so, as I said, it involves some type of violation of the penal code, of things that are written into the code book, and it's called Vernon Statutes of the penal code. And so what you're looking for this one is you're looking for some type of punishment, and that punishment can involve fines or it can involve imprisonment. Either you have to pay a fine, or you're going to go, or you are going to go to jail. So it involves those two. Okay, so when it comes to criminal law, it's really based on these different concepts of behavior that we have as a society, something that's morally wrong and that's defined by law. And so what happens is that if you commit a crime that's in one of these code books, like for example, I don't know of any state that says it's okay to kill somebody. So that would be like morality as defined by law. Something's going to happen to you. So you get arrested, you go in front of a magistrate, you go in front of the grand jury, you're going to have to go to court, so at that time you're going to have to enter a plea of guilty or not guilty. If you enter a plea of guilty, that means that the process is going to be a little bit different, like where you're going to be sentenced or whatever. Most of the time people plead not guilty because that means that you're going to get some kind of trial, a trial by your peers, by a jury. So this particular case is initiated by the government prosecutor or the DA's office on behalf of the public, as opposed to the civil cases. That's the person to person. This one says, nope, you committed a crime against the public. I'm the DA. It's up to me to decide if I'm going to file charges and what type of charges I will be filing against you as a perpetrator of this crime. Okay, so as I said, the charges are spelled out in the grand jury, and they're looking at what you're being charged with and if there's enough evidence to support whatever you're being charged with. If it's going to be, if you're being charged with, say, murder, it might really come out to be more like manslaughter. So they just have to look at the evidence to figure out, if there's what the charges are going to be. And not only that, there also has to be strict rules of how evidence is gathered. We have constitutional amendment rights. It says, anything that's going to be used against us in a court of law has to be gathered in a certain way. So there's strict rules of procedure to evaluate this type of evidence. And so what you're looking for is proof beyond a reasonable doubt. So in the criminal cases, you're looking for proof that this person is guilty beyond a reasonable doubt, because once you determine that this person is guilty, then there's going to be a punishment phase, and depending on that crime, the seriousness of that crime, it's going to render jail time and or a fine. So reasonable doubt just means that everybody has to agree. Everybody that's sitting on that jury agrees that yes, this person committed the crime. Otherwise, it's going to be a hung jury. And so they're looking. So they go through this whole process to say it's your peers, this jury has to evaluate all of this evidence to determine whether or not you did commit this crime. Okay, now this chart is from the book, and you can look at it. It tells you the differences between the civil cases and the criminal cases. So in plain English, I'm going to tell you the difference between the two cases. In order to establish your case, the burden of proof in your case. So for the civil cases, what you're looking for is preponderance of evidence. Whichever party is going to have the best evidence or present the best evidence, that's going to be more evidence of the proof that this person was responsible, because you're looking for responsibility. Now, in the criminal cases, the burden of proof falls on the prosecution, the DA's office, and that the DA must prove that the defendant is guilty beyond a reasonable doubt. So that's the catchphrase there, beyond a reasonable doubt, and that there must be enough evidence out there to substantiate the defendant's guilt. There must be enough evidence out there to point to the defendant as being the guilty party, beyond a reasonable doubt. Okay, now I want to talk about jurisdiction. And jurisdiction means that where a trial is going to be heard. When I talked about the executive office, I told you at that time that if a person commits a crime here, say in Texas or the county, Nueces County, for example, we're Nueces County, and then he flees to another state, that the governor can ask for that person to be extradited back, because a person has to stand trial here because the state and the county have jurisdiction of where this case is going to be heard. Well, that's what this is talking about, jurisdiction. All right, so original jurisdiction is which court should initiate the trial. Which county is going to be initiating the trial, and it's usually where the crime was committed is where the trial is going to be initiated. We're going to be talking about the appellate jurisdiction, where a trial can be appealed and why it can be appealed, what they're going to look for in appeals. And so basically this whole thing deals with where cases should be heard for the first time. Okay, let's talk about original jurisdiction first. Okay, it's where the case should be heard for the first time, where the trial should be heard for the first time. And so this is going to involve strict legal rules of procedures, and in the trial that they're having under this original jurisdiction, there's going to be lawyers. If it's a civil case, it's going to be the two parties, the lawyers for the two parties. If it's a criminal case, it's the DA's office with the person that's being the perpetrator. So this is where the trial is going to be held for the first time, and they're looking at the different legal rules of procedure that you have to go through when you go through a trial. And some of these things that happen in a trial is that this is where you will call witnesses to the stand to testify for or against or whatever. This is where all of the evidence is going to be shown to the not only the jury but also the judge. And this is the material that, or this evidence has to be gathered in the correct way so that it is admissible and it will not be thrown out based on some type of technicality. So the reason that they take testimony from witnesses and they present this material evidence, and not only the material evidence, now it's gotten to the point where there's a lot of forensic evidence, such as like the DNA testing, etc., etc. So it's not only things from the crime scene, like actual things, they will also do the forensic evidence, and that will also be presented. And so what you're looking for is you're looking for determination of guilt if it's a criminal case, or determination of responsibility if it is a civil case. Okay, so this is the process that's involved. There's a trial, that's what I was talking about. There has to be a verdict, guilty or responsible, and there has to be a judgment. I award you money, you're going to go to jail. And so the players in this process are the judge. He's the one that oversees the procedure. It is the jury of your peers that are going to be evaluating the evidence that's being presented during the trial by the different attorneys. And then the trial itself is actually the determination of fact and the application of law. And so basically what that's saying is that when a trial is going on, everything has to be done in a certain way. There's certain procedures that need to be followed. The way that evidence is presented, the way that discovery was conducted. So all of these things have to be according to fact and according to the application of law. Okay, a lot of times on TV you see that a person is found guilty of a crime or whatever, and so the first thing that they will say is, I'm going to appeal this case. The lawyer comes out, we're going to appeal this case. Well, guess what? Not all cases can be appealed. There's certain reasons why a case can be appealed, but actually very few are appealed. So let's talk about the appellate process or appellate jurisdiction. So if you're going to appeal a case, what they're looking for is they're going to be, or what the appellate judges are going to be looking for, they're going to be reviewing the decisions of a lower court. What the district court found goes up to the next level, which is the appellate court. Let's see what they found and how they found it. So it's not really considered to be a new trial. They're looking at the decision of the lower court. And so when they are reviewing this application of law, what the lower court did, it doesn't mean that they think this person is innocent. They're looking to measure or to find out whether the legal process was followed or if there were some improprieties. Okay, so let me give you some examples of this. It could be that evidence was suppressed. It could be that you did not have good legal representation. Those might be reasons for an appeal to be heard. So they're going to be looking at these things, the application of law in the original trial. Okay, here in the United States, it says a person cannot be tried for the same crime twice. Otherwise, it's called double jeopardy. But the thing is that once you agree, or once that person agrees to have an appeal, or to that they want an appeal, he waives that right, so a person can be tried again. So when this person agrees to the appeal, the person can be tried again because he or she waives that right to double jeopardy. Okay, some cases can be both criminal for breaking the law and civil for seeking damages. And the best example I can give you of this one would be the O.J. Simpson case. And I know some of you may be young and you may or may not know who O.J. Simpson is, but he was arrested for killing his ex-wife, Nicole Brown, and her friend, lover, whatever you want to call him. So he was charged with the murders, and it was a very long and drawn out trial. Well, for the criminal case, which would have been like the murders, he was acquitted. And acquitted doesn't mean he was found to be innocent. It means that there was not enough evidence to point to saying that yes, he was guilty beyond a reasonable doubt. Because at that time, when they were seeking all of this evidence, they went through this estate many times, and they never found a glove, and they call it the smoking glove. But it was a glove that was found way after the original CSI people had gone in to look at all of look at the criminal investigation to collect the evidence. And so that reasonable doubt, what it was, people were saying, was this glove planted? Was this glove planted way after the fact? So that in itself raised reasonable doubt and enough to get him off on that charge, for him to be acquitted of that charge. Okay, in the meantime, Nicole Brown's family sued him civilly in a civil court. And so they were seeking damages because they're saying, we think that he is responsible for their murders. We want him to pay for it. I mean, actually pay money for it. And so in the civil trial, they found him to be responsible. And so they awarded something like multi-million dollars judgment to Nicole Brown's family. And so it's never been paid. O.J. Simpson never paid that because when he saw, that there was this multi-million dollar loss judgment awarded to the Nicole Brown family, he just said, "Well, I don't have any money." He says, "I spent all my money on these high-level attorneys to get me off these charges." And so around that time, the book was going to come out. I think the book was called something like "If I Did It" or something like that. And so Nicole Brown's family went back to court saying, well, we want the royalties from this book because he's never paid anything on the judgment that from the civil case. And guess what? He decided he was not going to publish the book after all because he didn't want to pay any money to them. And in the meantime, O.J. Simpson is in jail for something entirely different. Odd, right? Just odd.